Greetings and welcome to today's program, Fiduciary Training for Retirement Plan Sponsors. My name is Kristen Kolish. I'm a retirement plan advisor at Raymond James, and I'm so excited to be speaking with you today. See, the timing of this conversation is ideal in my opinion. The start of a new year causes retirement committees to put together their annual to-do list. And I'm hopeful that today's discussion will serve as a great overview. Maybe you'll have some takeaways that you'll bring back to your fellow committee members. When we talk about employer-sponsored savings plans, whether it's 401k, 403b, pension plans, and the like, there's two stakeholders. There's the employer, and then there's your employee. Today's discussion is going to be focused on risk management and fiduciary responsibility for the employer. However, the other side of the work that my team and I do with clients is centered around the employee experience and making progress on their personal financial journeys. I believe that in the end, strong fiduciary governance not only protects the employer, but also helps the employees. So I'm going to start with a concept that I'm also going to end with. There's a lot of rules and requirements that we're going to talk through today. But if your overarching purview is that you are thinking about what is in the best interest of your employees, that's a great lens through which you're evaluating various decisions as it relates to your plan. So let's go through some housekeeping items. For joining the call today, you will earn an hour of SHRM PDC credit. I will be sharing the code along with a copy of the slides in an email to you before the close of today's business. So you will get an email from me with that, along with my contact information. At the end, I'll take questions through the Q&A box. However, feel free to reach out directly if you have any specific questions. I have one other overarching suggestion. Because you're going to get the slides, I ask you to just listen, to take this in, and choose maybe one or two actionable ideas that you might bring back to your committees for 2024. If you're like me, when I go to these sessions, I've got my notepad and I'm feverishly writing things down and super motivated, particularly this is me when I leave a conference. And then you get back to work and there's a laundry list of things for you to do, and maybe you don't act on the things that you were so hopeful that you were going to bring back to the workplace. So my challenge for you today is maybe pick one or two things I'm talking about that you would like to bring back to your colleagues. I am going to, well, another thing is I am recording this session and I'm happy to share that if you wanted to share this with your colleagues. The great thing about fiduciary training is that it is important no matter what level of expertise you have. So I can appreciate on this line, I might have some folks who are brand new to retirement plans, and I have others who are veterans. And particularly in today's current retirement plan landscape, it is very important to document that you've gone through fiduciary training. As a matter of fact, in my experience with my clients' auditors, and even going through a fiduciary insurance renewal process, both the insurers and the auditors are asking more and more about your fiduciary governance practices. And interestingly enough, actually going through training is a great way to document that you are aware of what your duties are and that you are on your way to following a prudent fiduciary governance process. So this does matter. It is important. It's a great refresher. And then also, if you happen to have new committee members or new employees come on board where they have responsibility for the plan, you should be working with your advisor to get them up to speed on what their responsibilities are. So I'm actually going to take myself off video. I find it maybe a little less distracting for you to focus on the information on the slides, and I will come back on towards the end. So in terms of our roadmap for today, I'm going to start off with outlining the role of a fiduciary. Now, I appreciate for some of you, this is a review and a refresher. So bear with me if this is something that you've heard before. For those of you who haven't heard it before, and if you're feeling a little overwhelmed, just take a breath, because the great part about managing a fiduciary process is that the Department of Labor cares more about that P word, process, than outcome. And we can control our processes. We can control having meetings. We can control documenting the discussions. Sometimes you can't control if a specific fund underperforms or outperforms. But if you focus on what you get to control and you document a process that arguably is prudent. We'll talk about how vague that word can be. So I'm going to demonstrate what actionable items might cause prudence. You're well on your way. So then we're going to talk about, once you're completely overwhelmed about all the things that you need to do as an employer, then we're going to talk about supports. Where can you go for help? And the great news is that the Department of Labor, while they are holding you to an expert standard, they are encouraging you to engage with you can I don't want to use the word outsource, but you can engage with prudent experts to help you through along the way. So that means hiring co-fiduciaries. We'll talk about that. So for my veterans on the call, I think that the third topic here is really going to be where you're going to be very interested. And it's the more timely topics about what fiduciary risks I'm seeing today in the marketplace. What are hot topics that I'm speaking to clients about, that in consultation with the ERISA attorneys we work with, that they're bringing to our attention. And then lastly, best practices for mitigating fiduciary risk. I will tell you, and I'll let you know when we get there, there are three slides that I think are worthwhile for you to bring back to your committees. And they'll serve as great either checklists or discussion documents. And I'll let you know when we get there. So let's start with some history. Another reason why I'm so excited about today's program is that we are in the year 2024, which happens to be the 50th anniversary of ERISA, the 50th anniversary of the Employee Retirement Income Security Act. And that is the legislation that oversees qualified retirement plans. Now, I do want to make you aware that while the focus of today, we are going to talk a lot about qualified plans, the idea of being a fiduciary is not one that's only captive to retirement plans. The word fiduciary really means that you're a steward of someone else's capital. So for instance, if you are a board member of your local nonprofit, you are a fiduciary because you are a steward for that organization's capital. You could have fiduciary responsibilities in your job. You could have fiduciary responsibilities related to non-qualified plans. So the idea of a fiduciary is that you're putting the interests of the beneficiary ahead of your own. So that's the overarching, like, kind of umbrella commonality of all fiduciary roles and functions. As it relates to ERISA, this is administered by the Department of Labor. And a little bit of a history lesson, it actually was passed before 401ks and 403b plans even existed. In fact, the catalyst for ERISA was failed pension plans. And there was a very infamous automaker, not currently in existence, Studebaker, that had made promises to thousands of retirees, and they went bankrupt. And over 85% of their retirees lost their benefit. And the government came along and said, listen, we can't have this happen. This is not in the best interest of the country. So we need to put some procedures, some safeguards into place. As part of that process, they were also concerned with discrimination. So if you are familiar with your 401k plan requirements and non-discrimination testing, you may be thinking, why on earth is this the approach that we've taken? And the reason being is that there was a concern early on that these plans would be used to benefit management and to benefit key executives above and beyond the rank and file. So that's the background. So here we go. Fast forward to 1978. And we have the Revenue Act of 1978, where the 401k plan was born. Back then, technology didn't exist. You had quarterly statements. It actually wasn't even participant directed. And in many ways, it came about because of a tax loophole. Well, in the early 1990s, the mutual fund industry drove the move to participant-driven investing and created demand for mutual fund products, which is common. A mutual fund is a very common investment vehicle today. In the early 1990s, it was relatively new. And over the course of figure 1990 through 2000, the dominant players in the 401k record keeping and administrative space were the mutual fund companies and the insurance companies. In essence, the 401k or the 403b was a vehicle for product and investment distribution. And it was not until the emergence of independent consultants in the early 2000s that they demanded what the industry calls quote unquote open architecture, meaning that you can offer your employees, if you're record kept at a mutual fund company, non-proprietary products. And that is something that we take for granted today, but I think it's worth understanding where we've come and how far the industry has come. Now, mind you, up until this point, not for a second was there a proactive view that defined contribution plans are the way that American workers are going to retire in the future. It was just this ancillary savings vehicle. But what's happened concurrently is that as defined contribution plans have ratcheted up in popularity for a variety of reasons, defined benefit plans are less popular. For one, they're expensive. But the way the American worker transcends their career path, defined contribution plans just make a whole heck of a lot of sense, because for a pension plan, you need to have stayed with an employer for a big chunk of your working years for that to make sense. So keep that in mind as we're thinking about the role that the defined contribution plan plays in your employee's financial picture. It has never been a more important part than it is today. So I'm looking back now to 2012. And that's a significant year in this industry because that's when the DOL passed fee disclosure requirements. And that is when the fee compression that we are currently experiencing and have been for the last 10 plus years really started. So now, up until that point, it was very often for a plan sponsor and for a participant for that matter to say, oh, I don't pay anything for my plan. And of course, if you think about that rationally, someone has to pay something because the providers and the advisors are not doing this for free. So it was oftentimes the investments had embedded revenue to cover the costs. And what fee disclosure did is it kind of peeled back the onion and said, look, you need to tell, they said this to the record keepers and to all plan providers, you need to tell your clients what you are charging them. And then in turn, sponsors need to tell their employees what they're paying in a very direct way. Well, direct, transparent, understandable. I think all those words kind of is a mishmash because what has transpired is that fee disclosures could be different for each provider. And it could honestly take me, depending on the provider, 15 to 20 minutes to read through a disclosure and truly understand what the cost structure is like. But in any event, this has led to a perpetual decline, particularly in record keeping and advisory fees, which is great for the person paying the fee, but it's had implications. So that's led to industry consolidation, whereby we used to have 400 plus record keepers in the defined contribution plan space. Now there's about 100. So that's a big decline. There's been industry consolidation amongst this thin margins. But the good news is that thanks to technological advancements, there's lots of different ways your employees can use these plans to make meaningful progress on their financial journeys. I will tell you, just as a trend, and this is my opinion, is that we're getting to the point from a pricing perspective where being in the business of record keeping defined contribution plans has almost become, I'd say, a loss leader. And you should understand how your partners are making money. Let's take a step back for a second. First, you need to understand what you're getting charged, what the plan sponsor, what the employer is paying, and what the employees are paying. And then in turn, understand, okay, well, how is this company making money? And we're going to get to it when we get to the section about hot topics and fiduciary concerns. There's nothing wrong with your plan providers making money in other ways, but you need to be aware of it. So we'll more on that. I'm going to put a pin in that for now, and we'll come back to that. So from a fiduciary perspective, how do I define this? Well, you are a fiduciary if you exercise discretionary authority over plan assets. You render investment advice for a fee. That's really the consultants and the advisors in my role. Or you have discretion over plan administration. Now, the key takeaway here is that fiduciaries under ERISA are held to a high standard, and breach of fiduciary duty can result in personal liability. So when I mentioned before, if this was relatively new to you and during this section you maybe start to get a little nervous, this was the bullet that I was thinking of, is that you have personal liability when it comes to your role as it relates to this plan. There are ways to mitigate that. So I don't intend to scare you for the purpose of scaring you, but to just elevate the conversation that this is really important. Now, one way to reduce fiduciary liability is to hire prudent experts. There's other ways to reduce the liability as well that we'll talk to. So what are the duties required of a fiduciary? There are 5. The first is something I've already alluded to, and arguably might be the most important: the exclusive benefit rule. You're going to act in the sole interest of plan participants and plan beneficiaries. Now, there's a practical aspect of this sole interest. Well, would it be in the best interest of your employees for you to quadruple your contributions? Yes, of course, but that's not feasible from a business perspective. So what we're thinking of here, sole interest of participants, is, you know what, you shouldn't be hiring your advisor or plan provider based on, for instance, what bank is lending you money. So that kind of ties into the bullet on the bottom, which is avoiding conflicts of interest. So really just thinking about what's in the best interest of your employees. You also need to exercise prudence in selecting suitable investments. Well, what the heck does that mean? What is prudence? Well, what the DOL would say is that prudence is what someone in an expert capacity, how they would approach things. And of course, there's no one way to approach things, which is kind of nice, because you could take your view of it. My suggestion is that a great way to demonstrate prudence is to have a written investment policy statement that is agreed upon by all parties and that is used to choose the investments and monitor the investments. I joke with my clients that oftentimes investment reviews, now the reviews themselves, there's a lot of exciting things to talk about plan usage and improving the plan. And honestly, what's going on from a legislative and regulatory perspective, it's been a super busy 24 months, but the investment discussion itself should end up at some point becoming pretty boring, right? Because you're looking at the same criteria and making sure that the investments continue to be prudent. That ties to the next bullet, which is offering a diversified investment menu lineup, the diversification rule. And of course, if you've hired a prudent expert, we'll talk about the different ways, the different forms of co-fiduciaries that you could hire to help in that regard. Following plan documents. So we're going to get to some best practices towards the end, but I'll give you a little spoiler alert, which is one of the things that I suggest plan sponsors do, maybe not annually, but every year or two, to sit down with your with the record keeper and the administrator, whether you're doing that in-house or utilizing the services of a third-party administrator, and compare your plan document to your procedures. That's a hot topic for plan audits. If you're doing something different than what your plan document says. And I should have said this at the beginning, but there is no plan that is perfect. And it's okay if you make a mistake as long as you're on top of it. And oftentimes there's operational errors that occur with operations versus what the plan document says. And then lastly, ensuring that expenses are reasonable. Now, it doesn't say ensure low cost expenses. It doesn't say ensure the cheapest cost plan. It's reasonable. So reasonable, what does that mean? That means reasonable for the level of service that you are looking for. So when you are benchmarking your plan from a cost perspective, you don't want to do it in a silo. You want to consider what are your expenses relative to the value you're getting, relative to the services provided by your various vendors. And that's an important component of this. Benchmarking is something that you can benchmark in one of two ways. We use a third party to pull information to compare our clients' information and other employers that we work with to similar size plans from a cost and service perspective. You could also just go out to bid and get a proposal, ask for proposals from various providers. Now, another point I do want to make is that if I look at the participants that are on this call, I'm going to have folks who are representing small employers, maybe $2 or $3 million size plans. And then you're going to have folks that could be with Fortune 500 companies and billion-dollar plans. And that's important to note that the rules are the same, even though the resources may not be. So for a large plan, you might be hiring a consultant to go out for an RFP on your behalf. But if you don't have those resources to do that, you still have to ensure that you are documenting and doing some diligence of what is the current market today. And I've actually spoken to prospective clients where auditors have brought this up and said, you know what, given the size of your plan, we think it looks expensive. And that's just a completely different purview than plan audits used to take. And as a reminder, if you have more than 100 employees in a plan, you would be subject to a plan audit. For smaller plans, you're probably thinking to yourself, what is Kristen talking about? I don't do an audit. Don't worry about it. You are not subject to one. So I mentioned that personal liability is could be a result of fiduciary breaches. Here are the details. Civil penalties, 20% on any amount payable in court order. There's, if it's a criminal penalty, it can be fines, even jail time. Now, what I will tell you is that in almost all of the breaches that I've ever read about, in most cases, there was not an intention to do wrong. It was more because of lack of awareness of what the fiduciary's responsibilities are, which is why today's discussion is so important. Of course, all of the participants on the call are not going to fall into that trap. You know that you could be personally liable to make good on losses to the plan or to return any profits resulting from a breach. Co-fiduciary liability for participating. If you're aware of something that's not above board and you don't stop it, that's also a cause for concern as well. So what can you do about it? Well, for one, and I think that this is the most important one, as long as a committee is meeting regularly, is engaged in the conversation with their vendors, I really do think that that is a very, very, very small minority of folks that are going to fall under that category. You may be thinking to yourself, well, can I ensure, when I think about risk and risk management, there are insurance companies that can provide help with that, right? That's what insurance companies do. They provide risk mitigation. Well, there's two specific types of insurance I wanted to bring up. ERISA fidelity bonding. That is a requirement of the DOL. Every plan must have a fidelity bond. It's required to protect against plan loss from acts of theft or fraud. For ERISA purposes, it is limited to 10% of plan assets at the beginning of the year, up to $500,000, and it can be paid out of plan assets. From a fiduciary liability insurance perspective, and then there's also a cap on that. But Fiduciary breaches are not covered by the fidelity bonds. That's where we fall under the umbrella of specific fiduciary liability insurance. So this is going to specifically protect against fiduciary duty breaches. It is not required. And honestly, depending on the organization, may or may not be needed. It can be paid by the plan, but you've got to make sure that there's actually, depending on if there's any payments out, if it should be owed back to the plan, and what the recourse provision is. My biggest suggestion for fiduciary liability insurance, first, you should ask your employer if they have it. Sometimes it is a rider on board or executive management E&O insurance. But the most important piece here is a duty to defend. So we can protect against, for the most part, you being sued and having a negative verdict. So the judge or jury or an attorney is able to prove that you did wrong. That's usually not the most expensive piece of it. It's anyone can make an accusation. So what protection do you have from a duty to defend perspective? What does the policy cover if someone makes an allegation that the fiduciary liability insurer is going to cover the cost to defend yourself in the court of law? Believe it or not, this has actually slowed in the last 6 to 12 months, but over the last 5 years, there's been a tremendous increase in the number of class action lawsuits. There's actually law firms that specialize in this. Though, as you know, the Form 5500s are public information, right? So they will search for plans that have had corrective action. They'll search for plans that have investments where the expense is high. And they reach out to employees and participants and try to get them to agree to join this class action lawsuit. And oftentimes, sometimes companies, it's more cost effective to settle than to go through the process of litigating the claim, even if the claim is not of sound mind. One that comes to mind is that I saw a class action lawsuit that claimed it was imprudent to offer target date funds that were not passive. So that because there was a cheaper option, it was imprudent to offer the active option. Now, in that instance, the judge said, no, that is not sound fiduciary mind. So oftentimes you might have very sound processes for making your decisions, but anyone can make a claim. So let's talk about the fiduciary supports you have. So I mentioned before, there's 3 slides that I think are worth bringing back to your organizations. This is the first one. What, in our view, are expectations that you should have for yourself and the retirement committee? And I think about these expectations through what I would call the 4 facets of retirement plan management. There's fiduciary governance and oversight, investment management, plan administration and cost structure, and then your employee experience, which would also cover education and communication. So under the fiduciary governance lens, you want to make sure that you are meeting regularly. So there's not a set period of time, but whether it's quarterly or annually, depending on the size of your organization and the scope of the benefits program. I mentioned before an investment policy statement. If you're not sure if you have one, reconvene with your committee and ask. If you have one and you're not exactly sure what it says, read it, and then engage with an investment advisor or consultant that is going to sign in writing that they're a co-fiduciary. And we'll talk about the different ways that they can do that. And then, which is kind of brings us full circle here, is having the committee participate in fiduciary training. So that's fiduciary governance. On the investment side, you want to make sure that your investments are reviewed based on objective criteria, ideally set forth in the investment policy. There are a few, this actually ties to some of the hot topics that I'll get to, but there's three specific concerns that I would have when it relates to your investment menu, beyond just offering a diverse array of asset classes. One is the qualified default investment alternative. So with the introduction of automatic enrollment, that actually came through the Pension Protection Act of 2006. That's when automatic enrollment was first blessed, so to speak. The whole idea of automatically enrolling someone means that they have not made a proactive investment choice. And the DOL acknowledged that there may be some concerns of committees who are making that choice on behalf of their employees. So they have outlined some criteria that gives you a safe harbor. And if the DOL is going to give you a safe harbor for something, or they're going to offer guidance, you better believe you should be following it. So following the guidance the DOL has provided as it relates to the choice of qualified default investment alternatives. Target date funds are investment vehicles that could fall under this umbrella, managed accounts, even balance funds. But you need to have documented that you've reviewed the options and determined that it is appropriate for your employee base. Okay, the second bullet here relates to proprietary investments. So a proprietary investment is when you are offering, for one, to have a proprietary investment, you need to be using a record keeper or administrator that is in the business of investment management, and you're offering their investments here. Now, some advisors believe that that's a hard stop. No, you do not offer proprietary investments. I personally don't feel that way. As long as you're following an objective criteria for evaluating the investments, oftentimes there could be an economic benefit to offering proprietary investment options if it has already passed the criteria in your investment policy. And then the last bullet is on share class, and that's making sure that the investments that you're offering is the lowest cost share class available, and that you are aware of any revenue that could be paid off of those investments and who is receiving the revenue, which kind of ties us to this next facet, plan administration and cost structure. You want to make sure you've documented that you've reviewed your pricing, you understand your pricing, and you've compared it to the industry. Oftentimes, this leads to a conversation which, excuse me, you could either get a fee cut with your existing provider and or an expansion of services, because this is not unlike many industries. It's like for a lot of service providers, their next client is their most important client. So going through due diligence is a great reminder to your current vendors that they need to continue to compete for your business on an ongoing basis. And that's where benchmarking has really been beneficial. I'll tell you, in my experience with clients, oftentimes you go through a benchmarking process. If there's an issue with service, sometimes it's better to change the service manager or the CRM before going through a conversion process. But oftentimes, by having this very frank and transparent discussion with your vendors, there's a way to Lastly, employee experience. You need to have been provided education and communication. That can come in lots of different ways. Where I see some committees get caught up is on the plan notices. There are required plan notices that need to go out. You want to make sure that someone is sending them out. I often see sponsors who think the providers are sending them out, and they're thinking that the sponsor is sending those out. So these are just four great high-level topics through which you could drive a committee agenda for meetings. So there's a lot of parties that touch retirement plans. You are the plan sponsor, you are a fiduciary. The administrative duties can either be done by a third-party administrator, it can be done in-house, or a combination of the two. You're going to have a trustee and custodian who oftentimes is the same company as the record keeper. You're going to have you may or may not have a financial advisor. That, believe it or not, that is not, hiring a consultant or advisor is not a requirement as set forth by ERISA. But it is difficult to run a plan, certainly without a record keeper. And then the investment managers, who are the investments that you're offering through the lineup. Have a little patience with me on this slide. It's kind of like numeric alphabet soup here. But this outlines under ERISA the different ways that you can outsource fiduciary functions. And the ERISA 338 is where you're hiring an advisor who is going to take discretion for your investment menu. I contrast that with ERISA 321, where the advisor is making recommendations to you, the committee, and you're making the decisions. So ultimately, who is the decision maker? ERISA 316 has more to do with plan administration. I see this oftentimes for smaller plans, startup plans. I encourage out of the gate to go 338 and 316, but it can get, as the plan gets larger, cost prohibitive. I would mention that ERISA 316 is not a yes or no proposition. There are aspects of your administration that you can ask a provider to take care of. So for instance, if you currently are in the business as the employer of approving distributions or approving loans, you got to get out of that. That's something that you can outsource to your provider, to the record keeper. And that's one type of 316 duty. But you could hire a full service 316 where they actually go so far as to sign the 5500, the form 5500 on your behalf. So oftentimes this is a cost benefit analysis. 408G, this is investment advice to participants, and this is going to lead into the discussion about managed accounts. And it's important to note here that the record keeper role is not considered a fiduciary function outside of the 316 requirements. Now, one of my suggestions would be there's a lot of providers who will offer service guarantees. We see this in RFPs a lot, where a record keeper will stand behind maybe a certain dollar's worth of fees if there's a hiccup as it relates to service. So that's something from a insurance perspective you can explore with your record keeper. And there's actually a similar concept that we'll get to on cybersecurity. So keep that in mind in terms of questions to ask your record keeper. One would be service guarantees. The second is going to be cybersecurity guarantees, which we will get to. And here we are at the top fiduciary risks and hot topics. We live in a litigious society, right? So you could see here it's kind of ebbed and flowed. In the year 2020, there was a lot of ERISA cases brought to market here. One of the trends we're seeing is that lawsuits used to really focus on the largest companies and the largest plans, and it's now coming down market. The news is not all bad. As I alluded to earlier, there are cases where plan sponsors and committees actually prevail, where a judge or a jury has decided in favor of the defendant, which is very interesting. I think that a bigger risk is the risk of having, let's say, an ERISA audit, and I'll get to in a moment a Department of Labor audit. You want to be aware of what are the hot topics for these two agencies. I'll share that the number one trigger for an audit is a participant complaint. Okay, so if the DOL, the IRS gets called from one of your participants with a complaint, there's a pretty good likelihood they're going to follow up with some type of audit action, which is why it is so important for you as an organization and for your service providers to take your participant concerns seriously, even if they don't seem logical or reasonable or rational. You want to make sure that you're aware of any gripes that your employees might have. So what I list on this page is the IRS top 10 compliance issues, some of which are not going to be applicable to you. If you're not in the business of mergers and acquisitions, the first one, and this is in no particular order, I should have said. Mergers and acquisition is a hot topic. Non-discrimination testing and making sure that you're following the plan document as it relates to the definition of compensation. That's a common operational failure where your document says one thing and functionally you're doing another. Failing to timely amend a plan document, that's where you want to have some co-responsibility with your service providers. Vesting schedules, the handling of distributions, plan fees, and how the assets of the plan are invested. So making sure that you're aware of what your plan fees are, who's paying them, and if they are reasonable. If there's been excessive deferrals. So these are items that you would hope that a plan audit would identify, and then a lack of internal controls as it relates to the management of the plan. DOL, I just mentioned this, trigger for an audit, participant complaints. The DOL is concerned about a float on your employee deferrals, so late deposit of deferrals. And I'll just spend a minute on this. To the letter of the law, it says that you have up to 15 business days to make contributions on your employees' behalf once you've withheld money, or whatever is administratively feasible, whatever is shorter. Well, with the advent of wires and ACHs, 15 business days is an eternity. So what I've seen from auditors is that if you've demonstrated that you can remit deferrals within 3 business days, and you actually remit within 5 or 6, that could be a breach because you've demonstrated you could do it sooner. And I actually have seen this with clients where there's been some turnover in payroll and they've had to make up some lost earnings there. So make sure that there's timely deposit of deferrals. Excessive provider fees, fiduciaries not knowing or fulfilling their duties. So that's a big piece of this, where there was actually a pretty well reported upon case with NYU, New York University's Retirement Committee. And the case was suggesting, the judge ended up ruling in their favor, but said that one of the committee members was very active and engaged, and that the others really put the organization at risk by just having no idea of what their duties were. So this is important. Imprudent investments. And then the last 3 are really plan sponsor specific. So let's explore some of these hot topics. I know that I've got 2 slides here that are a little wordy. Some of these topics we've hit on. Fiduciary investment advice. So there's 2 perspectives I want to think about this. One is your advisor acting as a fiduciary to the plan? They should be. The second is if you're offering managed accounts, there's a fiduciary duty there. And this is something that I'm seeing more and more of interest in the industry. Now, remember, I shared that there's been tremendous fee compression. So no surprise, plan providers are trying to find ancillary ways to generate revenue. Managed accounts is one option. Trying to get proprietary funds into the menu is another option. Offering IRA accounts outside of the 401k could be a third option. So you want to make sure that you're aware of what your employees are doing there, and what the conversations your service providers are having with your employees. My personal opinion of managed accounts is that as a committee, if you're offering them, you need to be aware of the cost structure. I think that they could end up being terrific investment solutions for employees, because the whole premise is that you're taking what you know about the employee and they can add additional information, outside accounts, other income sources, and they're going to get specific advice and recommendations that's managed over time. I just think the price point's too high today. And I think we're going to see compression there. Speaking of price points, that leads to the failure to consider all fees when benchmarking. So that's, again, I've used this word benchmark a number of times. You want to make sure that you've done that. If you haven't done it in the last 2 to 3 years, my guess is there's an opportunity for you to trim your fees or expand your service or some combination of the two. Last 3 topics, and this actually, the first and third here, there's some commonality. Based on the idea that your employees' personal information, their PI, is a plan asset, and it's a plan asset that you need to protect. So you want to understand how your service providers are using that plan asset, if at all, either within the plan or outside. I'm going to skip over QDIA for a second and go to cybersecurity because that's tied in with this whole idea of PI. In April of 2021, the Department of Labor came out with guidance for committees, vendors, service providers, and participants. There's 3 separate sets of guidance. And I have a QR code at the end if you want access to, or I can share it with you. They gave some suggestions for best practices. And here we are in April of 2024, it's going to be 3 years. So my suggestion is to go to your service providers and ask them to document that they are following these best practices and that they're doing it on your employees' behalf. Interestingly enough, educating employees about cybersecurity risks can be huge. I can think of one service provider that actually will give you a guarantee against cybersecurity breaches if your employees have opted into dual authentication. Yes, it's a pain in the neck. We know our password, but they're going to send us a code to our cell so we can get in. It's all for it's all in the purpose of protecting data. And one thing I learned that I did not know in going into this cybersecurity heightened environment is that if you have employees who are not comfortable transacting online, and let's say they have not actually set up a username and password, they're actually putting themselves at risk, because the majority of cases where distributions were actually made is when they didn't own their username and someone who's up to no good had, let's say, their social and date of birth and were able to generate a username and password and request a distribution. So education is an important component of managing cybersecurity risks. Lastly, we'll recap with some best practices. Some of this is going to be familiar based on what I've already discussed. This is the second slide that I thought would be great to bring back to your committees. 10 steps that fiduciaries can take to help manage these risks. Okay, first and foremost, you just did this one, right? Demonstrating that you've understood your roles and responsibilities by going through training. Perhaps you're drafting a charter to establish a committee if you haven't done that already, or in some other terms, formalizing a governance process, engaging with an independent advisor to act in that co-fiduciary capacity, drafting the IPS, conducting regular meetings, and here's the key, documenting them. In the world of ERISA, it didn't happen unless it's documented. So I would even make a note that you attended this training in January of 2024. Educate participants to help them make informed decisions. Now, that means something different for probably every organization on this call, but thinking about, and this is really where there's an opportunity to leverage your plans to elevate your overall benefits. That's a conversation for another day, but making sure that you've documented that you have provided some educational opportunities. And what can be offered through your plan providers are light years better today than they were even just a few years ago. So my other suggestion I said having a regular meeting, whether it's every year or 2 years, to review plan document versus operations. Have a meeting with your vendors and with your service providers and ask them 2 questions. The first, how do I use your services most effectively? What are the things we should be doing to leverage your capabilities that we're not doing today? And then secondly, what are you talking to prospective clients about? What are the services? What are your value adds that you're winning business on? And how should we be taking advantage of that? So that comes back to monitoring fees, complying with reporting and disclosure requirements, insurance coverage, certainly the bonds, the fiduciary liability insurance might be something to explore, and making sure that you are informed. I suggest that all plan sponsors maintain a digital retirement plan file, and these are the things that I would have handy. If you get notified that there's going to be an audit, if you're able to turn around and within a couple days' notice get all these things back to the IRS or the DOL, I don't know if it's worth their time to come on site and to dive into your files and whatnot. So this is an ounce of prevention can lead to a tremendous amount of cure here. And I would suggest that you go through this list to make sure that you at least know where these things are. Lastly, I do have a self-assessment here. It's through the work we do with FI 360, the Center for Fiduciary Studies. And it's a great conversation piece for committees, for you to identify maybe areas where you need to explore. Perhaps the word cybersecurity has never been spoken in your committee meetings. Maybe that's something that you should dive further into. Maybe you haven't looked at your fees in a while. Those are kind of low-hanging fruit that should become part of the conversation. To understand the safe harbors that are available, 404C, QDIA. I will tell you that from a cybersecurity standpoint, there's been some litigation there. There's also been litigation of late on the use of forfeiture accounts. So keep that in mind. A good best practice for you would be to review the plan terms for what is permissible use of forfeitures for your plan, and making sure that you're following that. So that's just something even that came across my desk in the last week that was timely, and I thought I would share. So this is where I started. Process is more important than outcome, and as long as it is documented. And ultimately, always focusing on what is best for your employees, the plan participants. That's really the lens through which all of your fiduciary obligations are ultimately going to be met. So with that, we have met the required time period to earn your credits. I do have 5 to 7 more minutes until the top of the hour here, and I would love to answer any questions that you may have. You can throw it into the Q&A box. I'm also including here my email address and a QR code to access some of the documents that I referenced as it relates to Department of Labor guidance. Oh, I see here, I got a question. You're reading the bullets here. What does crypto in retirement plans? What do I need to know about that? So I just see a question about that in the Q&A. This is another interesting one. About 2 years ago, and this was very uncommon for the Department of Labor, they came out with guidance that said that plan sponsors need to really go slow when it comes to crypto. And what was important about their messaging was that they specifically said, even in self-directed brokerage. So for the fiduciary geeks of the world, and I'd include myself in that category, if the DOL is saying that you can be held liable for crypto in self-directed brokerage accounts, what's to say that you're not held liable for other investments in self-directed brokerage? So this is one area that if you do offer self-directed brokerage accounts to your employees, it's certainly allowed. you do want to understand how they're using it and make sure that it's communicated to them that you are not monitoring the investments there like you are monitoring the core investment menu. Interesting. Good question. I am getting another question here on Secure 2.0. Secure 2.0 has really been, if you've been following the industry, you're probably in the camp of Secure 2.0 exhaustion, because that's really all we've been talking about for 12 plus months. It was passed December 29th of 2022. The thing to keep in mind is that of the 96 provisions, some are required and some are optional, and some will be required immediately, and some staged over a 5-year period. So the industry was very happy to hear that the requirement to have catch-ups be made through a Roth contribution for those making more than 145,000. So if you're not deep into the weeds, this may sound like a third language to you, but for those who are very well aware that Secure 2.0 has pretty much made it mandatory to have some type of Roth contribution, or a Roth contribution source, I should say, because for employees who make more than 145,000 and are over the age of 50, they delayed it. It was supposed to be January 1st of this year. It's now January 1st of next year. Those contributions are going to have to be made on a Roth or after-tax basis. Another one that's timely is the passing of long-term part-time employees and mandating that they are becoming eligible after a number of consecutive years of working at least 500 hours. So I would pause, and if you do have long-term part-time employees, to make sure, and I'm sure your vendors have reached out on this because it's effective as of today. There are other things that you may look to take advantage of, increasing the force out limit from 3,000 to 7,000. That's now allowable this year. There's also some guidance, or really some lesson requirements for self-corrections if you make an error. Really, the motivation of Secure 2.0 was to expand coverage. So there's all sorts of incentives. I'm assuming if you're on this call, you already offer a plan, but there's all sorts of incentives for business owners who don't offer a plan to offer one to employees. Expand coverage, and also to make it easier to administer in the spirit of the legislation, but we're still kind of working through that. So if you have any questions about Secure 2.0, you can also feel free to reach out to me. There is a white paper that I can also share that outlines the requirements. So with that, I would like to thank you for your time. I know January is a very busy time of year, and I hope that you found that this program was time well spent. For any questions, you could call direct at 833-440-4015. And as I mentioned before, you can certainly feel free to email me, and you should expect to receive an email from me by the end of the day with the slides and the SHRM PDC code. So with that, I wish you a great week, great day, stay healthy, and happy belated New Year. Thanks for joining.